Okay, we're going to go back on the record now. Mr. Gallagher, if you want to call your next witness.
I'd like to recall Mr. Hughes.
Mr. Hughes, you remain under oath from your prior testimony. Do you understand that?
Yes.
Weird setup here, but so Mr. Hughes, I know it's been probably 6 months, or close to 6 months, maybe more, maybe 6 months since you've last testified. Just to refamiliarize everybody, you are the project manager that's responsible for this project.
Yes.
And some iteration of this project began in 2021.
Yes.
All right. And since that time, there have been a number of you testified to this at your first hearing. There have been a number of review letters from the township's engineer, Mr.
Yes.
Hoffman. And I believe those have been identified as exhibits 13, 14, 15, and 16, which are comment review letters from Great Valley Consultants dated November 15th, 2021, January 31, 2023, March 14th, 2023, and July 11th, 2023.
Yes.
And Kimley Horn prepared responses to all of those letters from the township.
That's correct.
Okay. The first hearing you testified was on October 18th, and I believe that was the very first hearing.
Yes.
Okay. And the day of that hearing, you were given a 5th comment review letter from
Yes.
Great Valley Consultants. And that was dated October 17th, 2023.
Yes.
And consistent with how you responded to the first 4 review letters, did you prepare a response
Yes.
to that comment review letter? And that has been, I believe it's been identified or marked as Exhibit 232. T32.
Yes.
And this, what is the date of this letter?
January 12th, 2024.
Okay. And
Just one moment. Mr. Cluck, do you have a copy of that exhibit?
Yes, thank you.
Okay. Proceed.
okay. And this was a comment response. This was in response to that letter, correct?
Yes.
Okay. And this was submitted to the township?
Yes.
Okay. And in connection with that comment review letter, you also prepared a revised plan?
That's correct.
Okay. And I believe at the last hearing that was identified as Board Exhibit 31.
I don't see the number in front of me. I'll take your word for it. Okay.
And what was the purpose of revising the plan?
Primarily to address the comment from the township engineer related to mapping or delineating any slopes over 25% and depicting a plan that would avoid disturbance of those areas.
Okay. And did you prepare an exhibit that outlines, what do you mean in terms of steep slopes?
The letter specifically requested delineation of slopes of 25% or greater. We prepared an exhibit for the steep slope overlay section of the ordinance, which has a section related to slopes over 25%, but also slopes between 15 and 25%, for which there's allowable disturbance up to a certain threshold. So we prepared an exhibit to depict the ability for the project to meet those standards of the steep slope overlay district.
And I believe, which ones have been marked? Have we marked them yet? Anything? The stickers?
We've marked Board Exhibit 31 that's a copy of Board Exhibit 31. And then Board Exhibit 32 is the review, the response letter dated January 12, 2024. That's been marked. On the little, oh, are they different? They're different?
They're the same. these are bigger copies of this file, in terms of which one we want to mark. We're going to go through exhibits 53 through 56. We want to mark big copies or the smaller.
I'd rather we mark the big copies. I think it'll be easier for us to see.
So can you point to the steep slope exhibit you prepared?
This is the steep slope exhibit. It's titled Overall Slope Analysis Plan.
Just for terms of the record, this is the applicant's exhibit 53. Can you please explain to the board what exhibit 53 represents?
Sean, hold on for a second. 53 is one page or 4 pages?
4 pages.
And the first page is Overall Slope Analysis Plan, CP-01,
That's correct.
CP-02,
Yes.
CP-03, and CP-04. That is exhibit applicant 53. Thank you.
Yes.
Can you please explain? Can you please explain to the board why would this was prepared and what cash?
Yeah, in general, draw your attention to the shading on the plan. There's green shading and a reddish orange kind of shading. The reddish orange shading is the 15 to 25% slope areas. The greenish shading is the over 25% areas, and it's intended to visually depict the location of those slope areas in relationship to the proposed improvements. To the right of the plan, there is a tabulation of the percentages showing the impacts to 25% slopes is 0, and the impacts to the 15 to 25% within the 25% threshold allowed by the steep slope overlay ordinance.
Okay. And this is in response to the comment that the township provided.
That's correct.
Okay. And can you explain the differences in what has been marked as Exhibit T31, which is the original, or which was the plan that was submitted in January 2024, as opposed to the previous plan? Whatever has been A54. Marking what's been identified as exhibit applicant 54. What does this represent?
Exhibit 54 is simply an overlay of the October plan with the January plan. And what the intent of this plan is essentially that anything in green is new, red is old, so you can kind of see in contrast what has changed, and anything that's just in black or grayscale remains unchanged. So only the elements that you can see in color have changed, and again, this was the plan that was some minor revisions to accommodate a depiction of the feasibility of accommodating the steep slope overlay district.
And if you could just mark exhibit 54 just to show the board the limit of the changes.
Sure. The most dramatic changes are on the western portion of the Frederick parcel. There are also some...
What is that?
It's a reconfiguration of a stormwater facility, essentially. And also, one thing I didn't mention, some of the panels that were changed or moved around are depicted also in red or green. So it's all the elements, including where do we maybe add some panels to one area and remove some panels from another. So those are colored as well, which I may not capture all of these, but I can generally circle those areas. Yep.
So when we're talking about a different plan, this isn't a different design from the previous plan.
It's a layout, I would say layout revisions. I mean, I would say design is something that happens in land development. That's my definition of an engineered plan, but there's layout revisions of a minimal nature to, again, respond to the township engineer's comment related to slopes.
And again, the comment responses that have gone back and forth between you and Mr. Hoff, that's been similar to the comment response letter process that's gone through land development, correct?
Yes.
And that revision that's reflected in T31 is in A54. This is directly in response to the comment by the township.
Yes.
And they're not significant in that they would change any other major result, such as stormwater, well, aside from removing the basin.
No, but we updated analysis to treat that out. But again, all things that are conceptual and representative of the feasibility for those project elements that would be engineered during land development.
And in that response letter that we're talking about from October 17th, there were a number of comments that were made with respect to stormwater.
Yes.
Okay. And I believe that the township recognized that was your analysis was a preliminary analysis and that there would be a detailed analysis coming during land development.
Yes.
But you did provide responses, substantive responses to all of the comments.
Yes.
Okay. And did you follow up with the township engineer to see if there were any additional comments or
I did.
there were any questions? And
He simply responded, no, not at this time, or something to that effect.
okay. So you were also present for the testimony of Mr. Haig.
Yes.
Okay. And there was, I believe what's been identified as Exhibit 019.
I believe that was the review
The
letter.
comment
His comment
response
letter. Yeah.
Okay. How many projects, have you taken more than one project through conditional use approval?
I have. Yeah, I'm not sure how many, but several certainly have gone through conditional use processes. Yeah.
Okay. And all those projects, it's a two-step process.
That's
Conditional
correct.
use and then land development.
Yes,
Okay. And all of those projects, you've gone on to that more detailed review process.
that's correct.
And this project will require land development if
Yes.
approved. Would also require an NPDES permit.
Yes.
What is an NPDES permit? What does that cover?
Generally speaking, the NPDES permit covers earth disturbance for construction activities, and the primary elements of design reviewed and approved under an NPDES permit are erosion and sediment controls and post-construction stormwater management.
Okay. And what are those applicable regulations?
It's called what's called PA Code Chapter 102.
Okay. In order to obtain an NPDES permit, an applicant is required to demonstrate compliance with Chapter 102.
Right.
And who is the agency responsible for that permitting?
Pennsylvania Department of Environmental Protection.
I'm going to object. This is exactly what he testified to on direct. This isn't rebuttal.
Mr. Gallagher,
Yeah, I'm not going to belabor the point. This is just background. It's been 6 months since he's testified.
I'm going to overrule the objection and allow him to lay some foundation, but let's keep it going.
Yeah, understood. Thank you. Have you ever had an NPDES permit for any project at the conditional use stage?
No.
Okay. So there were a number of comments that were made in Exhibit 019. There was a section on the significant grading that was going to occur, or at least alleged to occur,
Yep.
where existing topsoil would be removed. Is that the case? Is that going to actually happen here?
No, the topsoil in areas where grading is prescribed on the final plan would be stripped, but then replaced on site. It certainly wouldn't be hauled away. That would be a great expense.
Okay. So it'll be stockpiled and then reapplied.
Right.
Okay. There were also comments with respect to stormwater and the managed release concept.
Yes.
Mr. Haig's testimony was that you cannot do managed release concept here.
Right.
Do you agree with that assessment?
I don't. The use of the managed release concept is subject to further investigation, and Mr. Haig had referenced the need for geotechnical investigation and so forth. He also referenced a citation of drainage area limitations of 3 acres. There is no drainage area limitation. It is simply a trigger to lead to a more rigorous review if something is submitted to a county conservation district. That regulation says it would go, or guidance says it would go to the PADEP district office for review. We've certainly had MRC, as we call them, facilities approved and permitted for drainage areas over 3 acres. So I don't believe that was an accurate interpretation.
Okay. And I guess that you prepared a memorandum, I believe, that you handed to me just tonight.
That's correct.
And I'm going to hand this out. I don't have a schedule for it, but
Can we go with the record to mark that, please? For any of our pro se parties, if you want to, anyone who wants to come forward and review this, there is a copy, or if there are additional copies that Mr. Gallagher can pass out. Thank you.
and can you identify what Exhibit 59 is?
Sure. After some of the previous testimony, I asked my office to pull records of 2 things. One, projects where there were slopes in excess of 15% that had received NPDES permits, and then also what I had just been alluding to, where we have managed release concept basins that were designed with tributary areas over 3 acres that had been approved and received NPDES permits as well. This is not necessarily an exhaustive list, but the important thing to consider is MRC basins can be on any kind of project site. So some of these projects are solar projects, some of them are other types of projects. The steep slope development was specifically to address any indication that projects like this are restricted on slopes over 15%. That's simply not the case, as evidenced by the 8 or 9 projects that we have received permits for that do have areas of the site that are in excess of 15%, and those are all ground-mounted solar projects.
And I think this is a correct assessment. You used managed release concept, I think you stated, as a worst-case scenario, correct?
I think of it as a conservative scenario. So one of the things we did before we did any stormwater analysis was coordinate with Steve Hoffman, the township engineer, to go over how we might conceptualize stormwater at this stage when we are simply trying to designate areas for stormwater management facilities without having gotten to the point of going through a geotechnical exercise. And using a managed release concept slows the water down, keep this simple, slows the water down in the control mechanism such that you need to have more storage volume and therefore would likely have a larger basin than other types of basins that might have infiltration or otherwise be allowed to exfiltrate water faster, at a faster rate. So we thought of that as a conservative exercise, which, not to speak for Mr. Hoffman, but he agreed with the approach for this conceptual phase of stormwater design. So it wasn't intended to be, this is exactly what the facility is going to be. Different portions of the same project site can have different types of facilities, and they often do. In this case, this initial concept, use manage release concept, as a conservative basis for conceptual design.
All right, thank you. So you just sat through Mr. Cleveland's testimony, and and what was identified as Exhibit 52. He recommended, in response to the comments that were raised by the other parties about the number of roads and the height of the panels, that additional studies should have been done. And he recommended additional buffers beyond what was provided for in Exhibit T31.
That's my understanding, yes.
And earlier, there was this testimony, or there was this questioning by Mr. Cluck about a forthcoming site plan with
Yes.
additional buffers. And Mr. Cleveland testified that he understood that the applicant was going to install these additional buffers.
My understanding is the applicant had agreed to implement Mr. Cleveland's recommendation
Okay.
for additional buffer.
And did you update the site plan to incorporate these additional buffers?
Yes.
And are you looking at a plan? This is something that Kimley Horn prepared, correct?
Yes.
And we'll identify this for the record as A55.
Yes, and if I may, again, we used a similar technique of only showing the new elements in color. So,
Can you differentiate which one is 54, which one's 55? They're all labeled overall site plan. They're all labeled C-100. They're all dated January 9. Which one's 54? Is 54 the one that looks like a black and white photo?
No.
so 55, 55 is the one that has all the buffering, prior proposed and new proposed in green, as well as the limit of disturbance line. I believe it's limit of disturbance, or is it parcel lines? Parcel lines shown in a reddish orange color. So the short answer is the plan that is 55 is the one with the more color elements. The more black, as you refer to it, black and white, is, I guess we'll get to this, is another plan that is simply an overlay where you can see only the new buffers in green and all the rest of the elements that hadn't changed in that black or gray scale.
Which is A56.
Which will be 56.
So just to summarize, everything that's in here, other than the additional buffer, is exactly the same as what is in Exhibit T31.
Yes.
And this just incorporates the additional buffer that was recommended by Mr. Cleveland.
That's correct.
And A56 just shows the difference between this plan, which I'm referring to as A55, and T31.
Yes.
And it's just a demonstrative.
It's just an illustrative overlay type of exhibit, yes.
Can you point on this exhibit where the additional buffer is with the difference?
Sure. Maybe I'll use Mr. Cleveland's language that I think he said an L shape along Monument Road. There is a couple portions on the southern and northern or central areas of the Gasperi property. And I think that's it.
Just to clarify, I was handed stickers that had 57 and 58. Whatever we marked as Exhibit 59, I I don't have a 57 and 58, so that would be 57. I know. What was previously marked as A59?
Is going to be A57?
Yes.
Okay. What are the dates on these overlay plans?
Oh. The date on the overlay plan for, which one is this? 54, sorry, is revision date April 29th, 2024.
Okay. What about 53? Or are they all the same revision date?
'56 is also the same date. 55 is the same date. Where's 52? What's 52? This one's just dated January 9th with no revision.
And just to be clear, there were hearings in January, and you intended to present that steep slope.
Yeah, I believe that was the intent at the time. I didn't get to it. Yeah.
Okay.
I have no further questions.
Mr. Cluck, cross-examination.
Thoroughly confused, so let me look at the big sheet and look at what I have. I have CP-01, the 4-page document. Show me the big version of it, please.
Sure.
And that's the overlay that has no revision date.
Dated January 9, 2024, no revision. When was this prepared?
All I have is the plan on the date. The date on the plan.
Was CP-01 prepared at a different date than January 9?
Saying the plan sheet says January 9th.
Well, when was this document prepared?
In advance, or on or about January 9th?
Did you prepare it?
I did not prepare it, no.
Who sealed it?
It's not sealed.
It's not sealed. Why isn't it sealed?
It's not
Did an
a,
engineer do it?
it's not a design document. Or it's not a construction document. It's an illustrative exhibit.
This one, overall site plan C-100, which exhibit is this?
That's 57. Should be 56. Yeah.
56, okay. And you're pulling up the large version of it?
That one's 55. This one's 56.
And the scale?
1 in 300.
Now, this one, exhibit 56, date January 4, 2023. On the right-hand side, I see revision 1, revision 2, revision 3. Revision 3 is January 9, and then it says for number 4, per landscape buffer update April 29 by TRF. Who is TRF?
Tyler French.
Okay, so this document, why is it dated January 4?
That's just the initial date of that particular version of the site plan, and the revisions are tallied thereafter.
So it's not February 27th, it's not October 18th.
No, that's the initial date of the plan, and those plans carry an initial date and then are revised. And you can see there's comments in the revisions based on the township engineer's review letters.
You sealed this one,
Yeah, that was part of the initial submission set.
so you didn't seal the April version?
Well, that's it.
Did you seal, which version did you seal, all of them?
This is the only plan that is a revision to the set that was initially submitted in January of 2023. The rest are illustrative exhibits.
Does your seal apply to the April revision?
Yes. And all that's showing is the additional buffer areas.
Okay. The next one, is this 54? Overall site plan CP 100?
That's 56. This one's 54.
Same thing. Dated January 4, sealed by you, 3 revisions, and the 4th of April. So this one, same question, same answer. And 55 is the last one, overall site plan. Dated January 4. Got it. Thank you. Keep them out, please. It's your testimony that these revisions were based on comments from Great Valley Consultants, correct?
Yes.
And you described this as the normal back and forth in land development. Is that correct?
That was the question as posed, and that is typically how a land development process goes, yeah.
Is this land development?
No,
No, it's conditional use, isn't it?
that's correct.
Does conditional use usually have back and forth with 4 or 5 letters from the consultant for the township?
It's actually pretty rare to get any letters at all, or there are times when there are no review letters at all, and having received letters, I believe it was our applicant's desire to be cooperating and being responsive to those comments, having received them.
And I believe, correct me if I'm wrong, the slope analysis of greater than 10% is because of the comments from Great Valley Consultants on October 17th?
The slope analysis in response to the Great Valley Consultants letter was really more for the over 25%.
I thought you already had over 25% on your plan.
He asked us to evaluate the improvements where we had, there were some improvements that were impacting those slopes over 25%. So we did a depiction to show the feasibility of the project without impacting the 25%, which I believe was the crux of his comment.
So his October 17 letter, which is Board Exhibit 30, he said in comments 2A and 2B that you had, the current plan does not comply with the no facilities on slopes 25% or greater, correct?
Yeah, in a nutshell, yeah.
And you testified on October 18, didn't you?
Yes,
Did you say that there was no equipment on slopes greater than 25% at that time?
I don't recall.
Do you recall that you had a list of prepared questions and answers that you and your lawyer worked on for that testimony?
I do.
And on page 5 of Exhibit 23, did you state the current conditional use plan submitted with the application in January 20, is in compliance? There is no equipment on any slopes greater than 25%.
I don't have the transcript, but
Do you deny making that?
no, I said I don't have the transcript.
So looking at the January 12 letter, let's go back. The original application for conditional use included plans that your firm prepared. I believe they were submitted in January of 2023. Is that correct?
That sounds correct.
And I believe it's Exhibit 3, and I'm not sure if that's a board exhibit or the applicant's exhibit. But suffice it to say, the original plans that are in exhibit is January 23, correct?
Yes.
On October 18, when you testified, you came in with revised plans, correct?
I believe that's correct in
And
October.
I'm sorry, don't let me interrupt you.
Yeah, what we refer to as the October plans.
Okay,
Yes.
so the plans dated October 18, did they have any equipment on slopes greater than 25%?
I believe they did, and you say equipment, I said it's really impacts, and what Mr. Hoffman was alluding to was grading and stormwater facilities. Just, you use the word equipment, just to be clear, so that's what his comment was suggesting. By the way, it also says that he says the land development plans will need to demonstrate compliance, not the conditional use plans.
Comment 2B. A portion of the block of proposed solar panels located several hundred feet northeast of DP 005 is located within areas with slopes greater than 25%. Is solar panels equipment?
Yes.
On the October plans, were those solar panels located on slopes greater than 25%?
I believe they were, and that's what Mr. Hoffman was commenting on.
But you didn't revise the plans until January, correct?
The January 9th
Do you
dated plans.
recognize that the applicant's case in chief closed on December the 5th, 2023?
I don't know that
And
date.
you had every opportunity to revise these plans prior to December 5th, but you didn't, did you?
They were not revised until January 9th.
You didn't do the slope analysis until January, did you?
I don't know exactly when the slope analysis started, but that's the date on the plan.
Well, let's talk about the differences between October plans and the January plans. What changes were made? And your testimony was it all involves responses to Great Valley Consultants' comment letter, correct?
Generally, that was the driver, yeah.
What other changes were made to those plans other than what was commented by GVC?
There were depictions of slopes, as we mentioned. There was adjustment of stormwater facilities and grading and movement of panels. I'm not recalling offhand if you're suggesting there was anything else that was done voluntarily or not otherwise a direct or trickle-down effect of responding to Mr. Hoffman's comment.
Do you have the October plans? And can you put them next to the January plans?
Well, that's what where our overlay exhibit is intended to do is to show the difference.
The October plan identifies a wetland buffer. The January plan does not. Why?
I don't know.
Well,
It's a
do you have,
call out that is on one plan and not the other. I'm not sure that's a direct change or a notable omission if a call out is changed. That's what you're referring to.
Is it your intention for the board to consider the January 2024 as the final conditional use plans for their consideration?
Yes, but with the added buffer. I believe that is our intent at this point is the January plan, let's call that as the base, with the, well, I guess we'll call it the April 29th additional buffer.
Is that depicted on another exhibit that you submitted? The entire plan?
No, it's one of the exhibits that we have that I think we can call that 55.
55.
So 55 is the plan that you want the board to consider as the final conditional use plan?
Correct.
Yes.
Okay. You understand this has become a little bit like a moving target for the board. It's hard to understand which plan, so
It's because, I understood, but there's two sides to that coin as well.
there are. I'm okay. So the board is going to is being asked to treat 55 as the final plan for conditional use purposes.
Correct.
Okay.
Yes.
Can proceed, Mr. Cluck.
Mr. Hughes, on October 18th, on page 207 of the transcript of this proceeding, you were asked the question, so this is the final version of the conditional use site plan for Mountain Trail Solar, correct? Answer, yes. So the October version presented to the board under oath, you testified that's the final plan. And you already had the Great Valley Consultants letter of October 17, didn't you?
Well, I'm sorry, what transcript are you or you,
Page 207,
just the date of it?
October 18.
Okay, go ahead.
I'll just say yes, that was the best information that we had at the time, and since then, the applicant had decided to present additional information on the plan to be responsive to comments received, but at the time, that was my understanding.
But the Great Valley October 17 letter told you there was equipment, solar panels on slopes greater than 25%, and you acknowledged in January that you would have to revise the plans. Wouldn't you have known that when you read the letter in October, before you testified on October 18 that these are the final plans?
Well, those were the only plans in play at the time. That was the application of record.
Okay, pull up the October version of the plans, please. Are they
Do we have this?
exhibit here? Applicant Exhibit 3, dated the revisions for October 18. And what I'm going to do is I'm going to compare C-101 with C-101 for the January 9 version. And I'm going to ask you questions. And I'm going to do that for C-102. Because there seems to be a number of changes between those two plans, and I want to identify what they are and why.
Okay.
C-101, there's a red dotted line. Do you see in the site legend what a red dotted line stands for?
No.
Well, I'll help you. It says Township Ordinance 25 Wetland Buffer, and I think that's 25 feet. You're looking at C-101?
Yes.
You see the site legend on the right-hand side?
Yes.
You see where there's red dotted lines?
I believe that's a different red dotted line.
What's a different red dotted line? The site legend or what's depicted on the map?
Well, there's two red dotted lines. There's a red dotted line with a little dot in the middle, and there's a red dotted line without the little dot.
What's a red dotted line with a dot? And where's that in the legend? I see project area, a solid red line.
So the easiest way to see this would be on C103, where there are locations to more clearly see that red line with dashes and dots marked as a 25-foot wetland buffer. The other red lines, I believe, are drainage area delineations. But on C103, it's more clear that there's a heavier line type without dots, and the lighter, thinner line type with dots is the wetland buffer identified in the site legend.
How many items in the legend are in red?
I think I'd call two of them reddish, one's pinkish.
Is that your answer?
I'm not sure what the,
Okay, pull up C-103 for the January version of the plan.
that's this.
On the right-hand side, it says proposed MRC dry extended detention basin number 6, parentheses, BMP number 17, DP006, parentheses, closed. Do you see that? Now, compare the October version of C-103 to the January version of C-103 at that location, and tell me why I don't see red dashed lines on the January version.
As I mentioned, those red dashed lines were drainage area delineations. They're not design features or wetlands or buffers or anything like that.
Where in the legend does that say it's a drainage feature?
It's not a drainage feature, it's a drainage area delineation. That's why it's turned off on this plan.
Is this explained to the township engineer anywhere? Is there a written document that sets forth what your testimony was about how to interpret your plans?
I'm not sure what you mean.
I don't know. I'm just a country lawyer. I'm trying to figure out what all the legend means. I look at the legend, I apply it to the map. You're now telling me, that's not really what the legend means. Is that accurate?
No.
Okay.
The legend,
What's wrong?
the legend has township ordinance 25-foot wetland buffer dash dot dash dot dash dot. Those line types are shown and marked as 25-foot wetland buffers. The drainage area delineation that was on the October plan, I will concede should have been turned off, frozen, as we call it in CAD, and that's why it's not appearing on the January plan. It's just a modeling delineation tool that doesn't need to be depicted on a site plan.
How many other things in the October plan are in error?
I didn't say error, you said error, but I don't know.
How many things from October are no longer depicted in January?
I don't know.
Well, you prepared them.
I did indeed.
You answered the question.
You sealed these as a professional engineer, and you can't tell me the differences between the two?
We provided an overlay exhibit to depict the differences between the plans in an exhibit this evening for this exact purpose.
Your October plans, your January plans, they do not depict slopes greater than 10% and less than 25%, correct?
That is correct.
When did you decide to add slopes between 10 and 25%?
I don't recall exactly when, sometime after the initial plan preparation.
Why did you do that?
We thought it was something that was necessary for rebuttal. I mentioned the township engineer bringing up the 25% slopes. We heard testimony from Mr. Haig related to disturbance of slopes and soils and things of that nature. So it felt relevant, albeit the township engineer simply indicated we needed to comply with that requirement in land development. We thought it relevant to depict, as I mentioned before, feasibility of the project subject to that requirement that we would have to meet in land development, and those requirements being the separate delineation of 15 to 25 and the over 25, specifically referenced by the township engineer.
Do you recall testifying at page 231 on October 18th when asked about why slopes between 10 and 15% were not included? I said, question, but not worth including on your conditional use plan? Answer, well, they're not required for a conditional use. So why should the board consider after your case in chief closed, delineation of slopes between 10 and 25%?
Well, this sounds like Mr. Gallagher's department. I'm not sure they need to consider it. It's something that the township engineer has stated in writing needs to be complied with at land development. But again, as with conceptual stormwater and other features on the plan, the applicant decided to depict more than might normally be on a conditional use plan to aid in demonstrating feasibility of certain things prior to engineering them for land development for I think, the benefit of the board.
So it's your testimony that these steep slopes between 10 and 25% are rebuttal to Bruce Haig, professional engineer's comments about your analysis, correct?
In part.
In part.
I mean, obviously the requirement existed in the ordinance, and again, the township engineer raised the question, but I think in part, that's one of the reasons we have the exhibit here tonight and as part of this rebuttal exercise.
Drawing CP-01, north of Hess Road, southwest of the substation. Also just north of Gruber Road. Do they both require significant regrading in the 15 to 25% slope area?
Well, I can answer that question without looking, which is that grading is what we call IFC level design task. The grading is also one of the elements that's been depicted conceptually. Final design requires a concert of engineering between electrical, structural, and civil, and one of the elements of that, one of the goals of that exercise is to minimize grading. We did some preliminary analysis to show where grading may be necessary, but in final design that would be subject to change, but certainly would not be able to exceed the threshold for the 15 to 25% disturbance in the ordinance.
Are you placing solar panels on slopes greater than 15% without regrading?
Yes, and in reviewing this with the township engineer, as far as definitions, our understanding is that interpretation is valid, that driving posts and hanging, racking, and putting panels up is not stripping and regrading earth disturbance and wouldn't be considered disturbance of those slopes.
Has DEP indicated that slopes greater than 15% causes accelerated erosion?
That sounds familiar. I don't know it verbatim, but that sounds something like that familiar from the solar farm FAQ document.
And DEP does not recommend placing solar panels on slopes greater than 15%?
Well, I think we've been over this. I have permits for over 8 or 9 projects where it's the guidance kicks you into a more rigorous engineering exercise per the FAQ, not a restriction. Whether they're recommending it or not is frankly irrelevant because they issue permits for plans with slopes over 25%.
How many of those
or 15%.
locations-
Sorry.
Finish your answer.
Sorry, I said 25%. I meant 15%.
How many of those locations, those jurisdictions where you have obtained DEP permits, have a local ordinance that limits or minimizes significant grading on steep slopes?
I don't know. Offhand, I don't know.
You don't know?
Aside from, again, the inverse inference, if you want to call it that, is those projects have been permitted, those projects have been approved by those local jurisdictions through land development, some of which are in construction or done construction.
You just said you have no idea what the local ordinance requirement is in all those other jurisdictions with respect to grading or regrading on steep slopes.
Well, I do have hundreds of projects, so I don't remember all the local ordinances.
Name one.
One what?
One where there is a requirement in a local ordinance not to put solar panels.
Objection,
on
this
slopes.
is argumentative.
Sustained.
I have no further questions.
Thank you. Mrs. Polana. Okay. Mr. Hartman. No questions. Mr. Hoffner. No questions. Mr. Yob. No questions. Mr. Balthaser. Mrs. Balthaser. Ms. Fowler.
Thank you for coming tonight. Can you show me on the new plans, page 2 and 3, where you show the steep slope overlay? So the first one would be the overlay page and then the detailed pages.
This is Exhibit 53.
How come on the online exhibit, this page is missing CP-03?
I don't know what is on the online exhibit. I apologize.
I just wanted to note for the record that on the online exhibit, CP-03 is missing. It shows a duplicate of page 2, which I assume is CP-02.
So noted.
You stated earlier that you're the project manager for this project. Is that correct?
Yes. Yes.
Who is your client?
My client is Mountain Trail Solar LLC.
So they pay you for your work?
Yes.
Okay. Were you involved in the Lion Solar Project in Richmond Township? It was listed on that paper that was handed out as an exhibit?
It is identified on Exhibit 57, so the objection will be overruled.
Yes.
What was your involvement in that project?
A similar role.
Are you aware of the water issues with that project affecting the farmer across the street with their drainage basins?
Yes.
Do you know anything about how they're going to fix them?
I don't. I hesitate to say too much for the record. My understanding is it's issue a construction phase erosion and sediment control issue currently between the contractor and the inspectors from the conservation district. So I can say, for instance, we as the engineer have not been asked to assess or redesign anything. I'm aware of that situation generally, and that it's an ongoing process. I don't know. I don't necessarily want to expound more than that.
Did they build the drainage basins as designed?
They're not in the final condition. They're in the during construction condition. My understanding is the conservation district has issued inspections that the contractor needs to do certain things to maintain them properly that perhaps are not being done. But again, they're in the temporary condition. They haven't been converted to the post-construction stormwater condition. So I can't comment on the functionality of the post-construction facilities. Just the during construction maintenance of the facilities appears to be the issue.
If you know the answer, how long does it take for a drainage basin to go from construction to being completely operational?
Well, it's a fairly quick process if you're referring to when the NA basin is being used for sediment containment during construction and then it gets converted. It gets converted very quickly. It's just there has to be a certain point of passing inspections and stabilization on the rest of the site before the Conservation District will give them the okay to convert it. I don't know exactly how long that would take. I would say it's a matter of days or short weeks, not months of work to do that, what we call conversion from erosion control to post-construction. I just don't believe they've been, because of whatever the during construction issues are, have been given the green light to convert it as of yet, and presumably pending stabilization of the grasses on the site.
Okay, that's all I had. Thank you.
Thank you. Mr. Fowler? Questions from the board?
Mr. Hughes, can we look at your Exhibit 55?
I'm sorry, you said 55?
Yes.
If I can find it. Okay.
Okay. On the Frederick property, I'm concerned about the scaling, okay? Based on your scale here, what's the width of these panels on the racks?
Based on the scale?
Yes, the scale in the lower right-hand corner.
I mean, I don't know what the scale is. I think there's a detail in here somewhere with a dimension. I'm sorry, not on this sheet, on the other plan set.
So
But-
your firm prepared these, they put these proposed solar panels on, overlaid on the property. My question is what's not the length, the width?
Yeah.
I mean, there's a scale right there where you have your hand at.
Well, it's a 1 to 300 scale. It wouldn't be very accurate, but I think there's a detail in here somewhere. But the width is based on the top-down area of that detail. Do we not have a detail? I'm sorry, we have a detail in the exhibit book, right? Sorry, I think there's a detail in the exhibit book.
About the site diagram.
That just the cross section of isn't there a cross section of the panel? Yeah, no. Yeah, that. The detail, I apologize, it doesn't have a stated dimension. It's what I'm referring to as Exhibit 12. So anyway, I don't know, unless we can find a detail, the exact dimension. Can you grab that?
So, okay, so let's just take a look at your drawing then. Back to 55.
55?
Yes. So, would you agree that whatever the width of the panel is, there's about equal distance between the panels?
I know where you're going with this. So
Where am I going?
that there needs to be more width between the panels, and there is.
That's not my question.
Okay, then I agree. It generally appears that way. I can testify that the dimensions are the panel width is less than the gap width.
Okay. Here's my perception. So we got the panels, we got the water control structures, then we, on Then there's a road down the middle where the inverter pads are at. Is that a road?
Yes.
Okay.
An aggregate surface or stone.
But it's impervious.
That's correct.
Okay. So my concern is just looking at that photograph, the way it's depicted on all these exhibits, and over in the right-hand column, zoning district requirements, you have somewhere around 20%, one's over 20%, one's under 19%. Maximum building coverage is 19.35, maximum impervious coverage at 20.34. Just my perception looking at that photograph, there's more than 20% impervious with the roads, inverter pads, and the solar panels. If the distance is roughly equal to the way it's depicted here in this photograph.
We did our takeoffs, impervious coverage calculations, and provided those along with our CAD files to the township engineer for cooperation. I don't disagree with you. I'll play Paul the layperson. The perception of this, it looks like a lot of panel coverage, but the exact takeoff, those are the numbers, and we did provide those to Steve to cooperate.
So you're testifying that the panels are impervious, and
Yes.
and there's less than 20% lot coverage. Or
Building coverage.
Building coverage.
One thing that might help a little bit is I'm looking at the other set where you can look at the larger sheets, and the spacing is a little more apparent for whatever that's worth. So on I'm just looking at the January plan, sheet 101. I think on the bigger plan, the printing of the line can only get so narrow before you can't really see it. So the line weight doesn't really change, but the blow up, you can see more clearly that the spacing is actually fairly significantly wider than the panels on the blow up plan on C101, well, on all the sheets, but.
Okay.
But we did make a point to provide that to Steve so that we had, again, cooperation on that, because that was one of his major concerns, along with some of the other feasibility exercises we went through, was just making absolutely sure that we were good with the coverage, especially since the project had gone through the zoning exercise prior to the conditional use application the first time.
So are you considering the panels, according to the zoning, as a building coverage or just impervious?
Both, yeah. We were asked, or we were required to count it as building. The premise for the zoning application was actually our attempt to get an interpretation that panels aren't buildings. That was denied, as those of you with the history know. So yes, they are considered essentially little buildings or building roofs, whatever you want to call it. But they're factored into the building coverage calculation. Yes.
That's all I had. I just want to make sure we are on the same page, because from a perception standpoint, it looks way over 20%.
Yeah. No, I agree with the perception, but can testify that our calculations and the township engineers' cooperation, that we can meet the zoning requirement for coverage overall and building. Thank you.
Is there any redirect?
Just very little. You were asked by Mr. Cluck, why did you testified on October 18th for the first time, and then you received a comment response letter on October 17th. And why didn't you testify in October 18th to the contents of that letter dated October 17th?
Simply because we had just received it.
I was going to say, did you just receive it the night you testified, right before you testified?
Yes.
So did you have time to even really digest it or review it before you testified?
I wouldn't say adequate time.
Okay. And the changes that were made, there's been a lot of discussion between the level of detail that goes into a conditional use setting like this and land development. And just to characterize, has this gone above and beyond any of your other conditional use applications?
Most of them, for sure. I can't recall if we had some similar exercises, but this is certainly more robust than a typical conditional use plan set that I've been involved with.
Okay. And just to be clear, the issue with the steep slopes, that the township said, to clarify, address that not now, but at land development.
Yeah, the township engineer's comment said that it would need to be addressed on the land development plans.
Okay, so there wasn't even a need to really address or change the plans other than to address that comment.
Right, yeah, we in reviewing with the applicant decided it would be, in more, good faith and providing additional information to show again, I'll use the word feasibility of the project, subject to those requirements,
Okay.
Albeit prior to land development.
I have no further questions.
Recross, Mr. Cook.
Mr. Hughes, your direct examination was October 18, correct?
Yes.
On October 18, did you have the Great Valley consultant letter dated
Hey,
October
just-
17?
Overruled, it's cross-examination.
Yes.
You were not cross-examined by me until October 24. Is that correct?
I believe you.
Between October 18 and October 24, did you have some time to look at the Great Valley October 17 letter?
Appears so.
So why did you testify on October 24 that those were the final plans? The October 18 plans were final, and that nothing else was greater than 25%. Were you lying then?
That was the plans. They were the only plans that existed at the time.
October 24, after you got the comments from Great Valley that your panels were on slopes greater than 25%, had you read the letter by that point?
I assume so.
And how did you respond to it internally?
I don't understand the question.
But did we have to revise the plans to address the comment?
Well, we didn't revise the plans until January.
Why not?
I don't recall.
After the case in chief closed, you then
Objections
revised the
relevant.
plans. No other question.
Wait. What's your objection?
Relevance. There's no,
Overruled. You may answer the question.
he did.
I don't recall. Was that the answer?
Okay. No other questions? Mr. Cluck?
Wait, what don't you recall?
I don't know. I don't remember what the last question was.
Will the court reporter read back the question and the answer?
After the case chief closed, you then revised the plan.
So what's your answer?
That sounds simply like a factual statement. Yeah, so yes, the plans were revised, and I don't recall the date that the case in chief was closed, so it sounds like the answer to that is yes.
That's it. I'm done. Thank you.
Okay. Mrs. Polonic? Mr. Hartman? No questions. Mr. Hoffner? No questions. Mr. Yob? No questions. Mr. Balthaser? No questions. No questions, Mrs. Balthaser. Ms. Fowler? Mr. Fowler? Any additional questions from the board? No additional questions from the board. Okay, this witness is excused.
Now, I would just ask to move for the admissions of exhibits 51 through 57.
Any objection? What's your objection?
52 is Mr. Cleveland's study, which I believe is new evidence, which is not appropriate in rebuttal. Exhibit 51 purports
Oh,
to...
wait.
Oh, 52, we'll stop at 52.
Let's do them one at a time because it's late and my brain is only so big. So you're going to confuse me. So 50
is not proper rebuttal.
is not proper rebuttal. Mr. Gallagher, what's your position?
I mean, we've already had two hearings. It was directly in relation to rebuttal or to the applicant or the objectors, multiple objectors' comments with respect to our exhibits. I mean, there's no rule against presenting evidence during a rebuttal case, it's still a case. There's still evidence and testimony presented. There's no basis for his objection in law.
I don't think that his objection is that you can't produce evidence. My understanding of the objection is that the nature of that evidence needs to be in rebuttal of prior testimony. So how do you address the fact that Mr. Cleveland was essentially did a new study that you were trying to admit into the record after your case in chief was closed?
It wasn't a new study in as much as it was in response to, there were comments made that there were not enough roads modeled, and there should have been an additional height studied, and that's exactly what was done. So it's our contention that the original study is still valid, and the second study was done to respond to everybody's alleged critiques of the original report, and it's directly in response to those issues, so it's proper. And I mean, we spent probably a combined 5 hours discussing all of it.
Mrs. Polonic, do you have a position on this?
To me, it feels like new evidence.
Okay. Mr. Hartman? Mr. Hoffner, you think it's new evidence? Mr. Yob, okay. Do any of you want to tell me why you think it's new evidence? I'll get to you in 1 second.
I understand they did it in reference to questions that were brought up, but rebuttal was not producing the thing to talk about the old thing. I consider things.
Understood. Mr. Hoffner, did you want to add anything?
No, pretty much.
Okay. Mr. Yob? Mr. Balthaser? Mrs. Balthaser?
Oh, I definitely think it's new evidence, and I've been an analyst for 28 years dealing with the Public Utility Commission and dealing with reports that come back and forth. And rebuttal is always, here's your question, here's your response. Here's your question, here's your response. There is never a time when you recreate a document and submit a new document. So definitely new evidence.
Ms. Fowler?
How about now? Okay. I consider it new evidence because they used it with new plans. They used the January 2024 plans, which I still haven't had a chance to see a copy of those because they're not online yet. So I think that's new evidence. And when I cross-examined Mr. Cleveland, he mentioned that he used the same data to start his own analysis from the Kimley-Horn study. So why should we have two studies if they're using the same data? They're not two independent studies. So I object.
Mr. Fowler?
I'm not sure if it's specifically an objection to the specifics or it's just kind of a general objection. I just think the situation's somewhat unfair to the board as well as to the objectors who've put on their case. We've spent research time, we've spent money to defend this case against the evidence that was presented, and it seems like the applicant gets to redo things that we point out are faulty. And at some point, that seems like that shouldn't happen.
So to a certain extent, rebuttal is an opportunity for the applicant to do some of what you said, Mr. Fowler, which is they have the opportunity to listen to the opposition and try to present a rebuttal to that. I don't think that extends to producing new evidence. So at this point, the admission of the objection to the admission of Exhibit 52 will be sustained. The exhibit will not be made part of the record. The testimony, however, of Mr. Cleveland will stand and will remain part of the record.
And can I respond to that on reconsideration? Or I would just state that it seems like there's been a double standard on the evidentiary rulings. It's been stated several times that this is not a trial. It's not a court with a judge and the technical rules of evidence apply. The controlling statute is the Pennsylvania Municipalities Planning Code, and the rules of evidence, it clearly states in the statute that the rules of evidence do not apply. And
Mr. Gallagher, you make that argument when it benefits you, and then when it doesn't benefit you, your argument is that it's not evidentiarily appropriate to introduce something. So you know, I know I've said this before, but you can't have it both ways. And I think that when we look at the purpose of rebuttal, the purpose of rebuttal is to rebut testimony, not to introduce new evidence. You didn't make a motion to reopen your case in chief.
okay, so as I said, I mean, the transcript, that's why we have a court reporter here. This has been a very organic process over the past year, and you know, I've stated what I needed to state. So,
Okay. All right. The next exhibit that you have an objection to, Mr. Clark?
51, if I recall, is Mr. Cleveland's response primarily to Mr. Haig. Haig had numbered paragraphs. And my recollection is the overwhelming majority of the responses from Mr. Cleveland failed to identify anything inaccurate in Mr. Haig's comments. Therefore, that's not rebuttal.
Do you have a response?
this is borderline. Yeah, I mean, he spent the better part of 3 hours going through each response. There were letters submitted by Mr. Cluck in comment form, and as well as Mr. Balthaser, and incorporating that format, which everything was permitted. He filed responses specifically addressing those comments and testified at length to each and every one of them.
That objection is overruled. That exhibit will be admitted.
The January 9th site plans, what number is that? 50?
It's township. It's been marked as identification as board exhibit 31.
What was the 30 is the Great Valley letter?
I believe that 30 is the Great Valley letter. 31, I'm sorry, township T32 is the response, the January 12th, 2024 response.
Okay. I want to start with the January 9 site plan.
Okay, so that is township or T31.
T31 is new evidence submitted after the close of the case in chief that could have been submitted in the case in chief, and it clearly is not rebuttal, but my case didn't start until January 17th. So this is a revision to the site plans after the case in chief with no basis for, it's not rebuttal, it's new evidence, and you heard the testimony tonight of some of the things that were there, with not just in response to the GVC letter, but more importantly, even if it is in response to the GVC letter, it should have been done in the case in chief.
Okay. Mr. Gallagher, why wasn't this plan introduced as part of your case in chief?
So, I think after 6-8 months, we have the same conversations and they kind of get glossed over, and I can't remember what is on the record and what is not, but there was a specific response letter, and it's like sometimes we have gone above and beyond, as Mr. Hughes testified. No, it's not typical to get comment response letters in the conditional use process. We've had 5 of them, and it's not like you can just do the engineering and respond to these things within a day. So over the past 3 years, we have followed the township's preferred process, and we have done what is necessary. We got a letter the day before our case started, and it took time to make revisions. And if you recall, we had, I don't even know, 5, 6 hearings between October and December. So, sometimes everybody needs to take a pause and actually do the work. So I think it's an unfair burden to have us respond immediately in that process. And we were just responding in the regular course of proceedings since we filed.
That wasn't my question, though. I completely understand what you're saying, and I believe I speak for the board on this. Do not have the expectation that you would have a response to an October 17th letter on October 18th. Not one that is as detailed and technical as what we're talking about. But my question is, you knew about this letter. You knew about this letter when you rested your case on December 5th. Why did you not make any reference to this plan or otherwise try to have this introduced in your case in chief?
There's no requirement to finish in this context. This has gone so absurdly above the normal that the record is still open. We're in a conditional use process. So as Mr. Haig testified that he received these plans timely when he testified. We submitted them when we could, and we've now had 6 months of additional hearings. So I don't know what to say.
Mr. Cluck, how are you prejudiced by these plans being admitted into the record?
Tonight's example of all the exhibits on slope, of Mr. Cleveland adding buffers, adding roads, more buffers being added. How many changes are we going to make, and how many witnesses am I going to need to rebut their rebuttal? That's not what conditional use is. They had a burden. They have to meet the express criteria. They had to do it in their case in chief. I'm going to argue they haven't done that. That's it.
Okay. We met our burden.
Well, we can argue that.
Yeah, that's a
now.
separate argument. We've met our burden. All these changes are not significant changes, and it's not like it's a new plan. These are very minor changes. I mean, they're insignificant on paper when you're like, oh my God, there's all these new plans. My mind, I can't take it. It's so small. There are insignificant changes that are directly response to the township's review letters.
He was unable tonight to identify the changes between October and January, and he couldn't even identify what's in the site legend. How am I prejudiced by that? I'm prejudiced because they can't even explain their plans.
He explained the plans. I mean, he went through and answered every single question you had.
Okay. Mrs. Polanic, what is your position?
I'm going to be proper and say nothing.
Mr. Hartman,
I agree with him.
you agree with Mr. Cluck? Mr. Hoffner? No comment. Mr. Yob? Mr. Balthaser?
Changes are very extensive here. He said it once. He thinks the expenses for all the objectors and attorney's fees and everything else.
Mrs. Balthaser? Ms. Fowler?
I agree with Mr. Clark.
Mr. Fowler?
I also agree with Mr. Clark.
And I would note that almost all those questions and all those issues that were raised are in the land development context anyways. So
If that's the case, then it should not matter whether or not this plan is admitted into the record or not.
It does. We did it. We've testified at length to the reasons why, and it's proper to be admitted.
Okay, I'm gonna hold that objection in abeyance because I know you have an objection to T32.
That's the January 12 response.
That's the January 12, 2024 response letter. Do you have an objection to that?
If January 9 plans are, if my objection is sustained, then the same rationale would apply to the January 12.
Okay, so it's the same argument.
Yeah, but the January 12 letter goes to land development. So when it's time for them to deal, if they ever get to land development, then the January 12 letter is relevant, but it's not relevant to the conditional use.
I would put it this way, this letter was, from the township engineer, was issued in response to conditional use. But most of his comments, so they were issued in this proceeding. However, most of the comments acknowledged that it was forward-looking to the next step in development.
Okay. Do you have objections? Because I want to be able to discuss this with the board before we make a ruling, but I don't want to be going in and out. So if you have other objections on other exhibits.
We did 51, we did 52, 53, 54, 55, 56 are all related to the January 9 plans. 57 is just the Kinderhorn list, no objection to that.
Okay.
That's it.
So, yep, 57 is admitted.
Board exhibits, we just talked about. The GBC letter signed. The response is whatever that letter. No additional objections to other exhibits.
So you're not objecting to 53 through 56?
No, I said I am.
Oh, you are, but the same arguments.
Right. If January 9 site plans, if my objection is sustained, then then obviously that applies to the rest of the exhibits.
Okay. All right. So then the board is going to go into an executive session for the purpose of considering these, and we will come back in a few minutes.